Damages are really important. It is what drives lawsuits. Generally, people do not file a lawsuit unless they've been damaged in some sort. Now, there are two broad categories of damages. They're going to be compensatory and non-compensatory. Now, compensatory just means compensation. It means you've been hurt, the scales of justice are no longer equal, and to equalize them, we are going to give the person money in compensation for what they have lost. Now, non-compensatory damages is you're going to give somebody money that doesn't compensate them for anything. Now, that's a little weird, I get it, but what that generally is referring to are things like punitive damages or exemplary damages. These are damages that we are going to use to punish somebody. So for example, let's say that somebody throws a baseball through a window on accident. Now, the person who threw the baseball through the window is probably going to be liable for replacing the window. Let's say it's $300. So they're going to have to pay $300 to get that window replaced. Now, let's imagine they did it as part of a hate crime, that they want to torment the person inside, and so they broke the window on purpose. Not only should that person pay the $300, but the judge very likely is going to punish them for, let's say, $1,000 or whatever it is. That would be non-compensatory. Let's talk about compensatory damages. Now, as we talked about earlier, compensatory is a category of damages, and it is to compensate somebody for something they've lost. Now, there are two broad categories of compensatory damages: economic damages, we also call those special damages, and non-economic damages, which are general damages. Economic damages are those things that you can ask for a receipt for. Let's say you go to the doctor, you go to the emergency room, the emergency room charges you $5,252.32. We can ask, did it really cost that much? You say, yes, it did. Here's the receipt. Now, let's say that you have general damages, pain and suffering. Those are non-economic damages. The emergency room is going to be the economic damages, but the pain and suffering is going to be the non-economic damages. And you say, well, I have non-economic damages of $5,233.25. Can you give me the receipt for that? And the answer is no. I can't, because there is no receipt. Now, non-economic damages can be a challenging concept for the jury, because again, there's no receipt. And not only that, the payment of the $5,200 in the example we gave does not actually make the person better. They can't go out and buy something with it that undoes their harm. Let's say that, for example, in a wreck, somebody loses the use of their hand gets crushed, and there's a lot of pain, maybe a couple of fingers are amputated, and the hand is never quite the same again. How much is that worth to a jury? Because that's ultimately the question. Whenever we're talking about how much an injury is worth, we're always asking, how much is it likely to be worth to a jury? Because that's ultimately who's going to be deciding. With the economic damages side of that, well, we can say, well, the loss of the hand, $250,000 in medical bills, and now he has to go get new employment, and he's going to lose out on maybe $200,000 worth of employment. Okay, great. We can actually put pencil to paper and figure that out with some precision. But we can't do that with the pain and suffering. In fact, the judge is going to tell the jury that there is no methodology that is accepted by the court for the determination of pain and suffering, and that the jury is going to have to use their common sense and their reason. Now, at that point, the attorneys are going to step in. The defense side is going to say, well, no money's going to bring it back. And so let's give him, $10,000, maybe $100,000, and send him on his way. The plaintiff side is going to do something differently. The plaintiff side is going to try to give a methodology that will make sense to the jury. For example, the plaintiff side might tell the jury, listen, no rational and reasonable person would voluntarily get their hand crushed in this way. But let's say we had a rational and reasonable person, a panel of them, here in this room, and we were to ask them, how much would you charge in advance with full knowledge of what's going to happen to voluntarily go through this? Would a rational and reasonable person do this for $10,000? No, I don't think so. Would a rational and reasonable person agree to have their hand smashed and forever maimed for $100,000? No, probably not. For $1 million? Well, you might actually have some jury members start to think, well, maybe. For $10 million, there's going to be a number where a jury is going to say, yeah, actually, we think that would be fair compensation. Now, another way that plaintiffs' attorneys will do this is they'll do what's called the per diem, or the per day. And they'll say, okay, well, let's take a look at 2 years after the person's hand's been smashed. The pain and suffering from the event is gone. Now he just has to live with this hand that is maimed. How much would you charge to live with a maimed hand? What would a rational person charge? Is it $100 a day? Is it $50 a day? Is it $200 a day? Then you go and you try to figure out how many days this person on average has left to live. And then you ask the jury to multiply the two, and there you have your number. Damages are really what drive a case, and pain and suffering damages, depending on the type of injury, really are the main driver, because while somebody might have a $250,000 hospital bill, they might really have a $5 million injury, because no rational and reasonable person would go through what this person did for less than $5 million.